Good evening, students. Welcome to my YouTube channel, Short Questions with Narayan. Today I cut off with cold and cough, so please bear with me. So in this video, we are going to discuss about some of the important questions likely to be asked in the semester exams of BLLB, BLLB, BBLLB, and also this is important for the students who are aspiring to appear in CLAT, ISLET, DULLB or LLM entrance exam of other universities. So today in this video we are going to discuss about law of tort, especially negligence, what is composite and contributory negligence, what is the legal maxim, res ipsa loquitur and nuisance. So let's start one by one. Question number 1. Explain the theories of negligence in the law of torts and discuss the key elements that must be established to prove negligence. The answer is negligence is rooted in the principle that individuals must take reasonable care to avoid foreseeable harm to others. The two theories of negligence, one given by Salmond, other one is given by Pollock. Let's discuss one by one. Theories of negligence. One is subjective theory that is given by Salmond. According to this theory of Salmond, negligence denotes state of mind. A person is liable only for his intentional acts only and not otherwise. If a person has acted to the best of his ability, then he cannot be held liable for negligence. Coming to the next theory, that is objective theory. According to this theory of Pollock, negligence is a type of conduct which could be avoided with a reasonable degree of care and caution. This theory is concerned with the conduct of the person and not on his state of mind. So here you need to remember this key word. It is the state of mind, and here it is only for the intentional acts. Subjective theory is dealing with only intentional acts and objective theory is dealing with only the conduct of the person but not on his state of mind. These two things you must remember. The key elements that must be established to prove negligence are: one is duty of care. The defendant owed a legal duty of care to the claimant. This means the defendant was required to act in a certain way to avoid causing harm to others. Example, a driver has a duty to follow traffic rules to ensure the safety of pedestrians. Continuing with question number 1. One case law is Stansby versus Troman, case of 1948. Here the plaintiff Troman hired the defendant Stansby, a decorator, to perform some work in their house. Stansby was left alone in the plaintiff's house to complete the decoration work. Incident: what happened there? Before leaving the house, the plaintiff specifically instructed the defendant to lock the doors. However, the defendant, while in the house, left the door unlocked when he went out to fetch supplies. As a consequence of his act, what happened? As a result of the door being left unlocked, a burglar entered the house and stole valuable items from the plaintiff's property. The judgment was given by the court as the defendant was held liable for his negligence as the breach of duty led directly to the burglary and the subsequent loss to the plaintiff. This case is significant in illustrating how a breach of duty in tort law can lead to liability even when a third party, the burglar, directly commits the wrongful act. Number 2 is the duty must be towards the plaintiff. A duty arises when the law recognizes a relationship between the defendant and the plaintiff and requires the defendant to act in a certain manner towards the plaintiff. Second case law is Borhill versus Young of 1943. The plaintiff Borhill got down from a tram car, and while she was being helped in putting her basket on her back, a motorcyclist, after passing the tram, collided with a motor car and died instantly on the spot. The plaintiff did not witness the accident or the dead body. She visited the place and saw some blood which was left on the road. Due to this, she suffered a nervous shock and gave birth to a stillborn child of 8 months. She sued the representatives of the deceased motorcyclist. Judgment: it was held that the deceased had no duty of care towards the litigant. The relationship between the accident and Mrs. Borhill's injury was too remote, and Young could not have reasonably foreseen that his negligent driving would cause harm to someone not directly involved in the accident. The court found that it was not foreseeable that Young's negligent driving would cause her psychiatric harm. Another question is Donogh versus Stevenson of 1932. The plaintiff Mrs. Donogh's friend ordered and paid for a bottle of ginger beer for Mrs. Donogh from a cafe in Paisley, Scotland. The ginger beer came in an opaque bottle, so its contents could not be seen. Mrs. Donogh drank some of the ginger beer and then poured the remainder into a glass, where she discovered a decomposed snail at the bottom of the bottle. She claimed that seeing the snail caused her shock and severe gastroenteritis. The claim: Mrs. Donogh could not sue the cafe owner since she had not purchased the drink herself. Instead, she sued the manufacturer, Mr. Stevenson, for negligence, arguing that he had a duty of care to ensure the product was safe for consumption. Judgment: the House of Lords, led by Lord Atkin, held that Mr. Stevenson, as a manufacturer of consumable goods, owed a duty of care to the ultimate consumers of his products. Lord Atkin introduced the neighbor principle, stating that a person must take reasonable care to avoid acts or omissions that can foreseeably injure their neighbor. Neighbor could be defined as anyone who might be directly affected by their actions. The breach of duty: the court found that Mr. Stevenson had breached his duty of care by allowing the bottle to be contaminated with a harmful object, the snail. Foreseeability: it was foreseeable that if the manufacturer did not ensure the product's safety, consumers could be harmed. Pictorially, it is shown this is a bottle of ginger beer and this is a snail, the creature. So you could relate this picture, keep this picture in your mind while writing the case laws in your semester exam or your annual exams. And one thing must remember for the people who are preparing for the entrance examination, the neighboring principle was evolved in this case of Donogh versus Stevenson. It was evolved by Lord Atkin. Breach of duty: the defendant breached this duty by failing to meet the required standard of care. This could be by doing something that a reasonable person would not have done, or failing to do something that a reasonable person would have done. Example: during a surgery, the doctor fails to sterilize the surgical instruments properly. Here, wrongly, it is during a surgery. Please remember, it is during a surgery. I am sorry for this lapse. Please manage with. During a surgery, a doctor fails to sterilize the surgical instruments properly, which is standard procedure that any competent doctor would follow. The doctor owed a duty of care to the patient to perform the surgery with reasonable skill and care. The doctor breached this duty by not sterilizing the instruments, an action that falls below the accepted standard of care. The breach caused harm, but that means infection to the patient, which would not have occurred had the instruments been properly sterilized. So pictorially, these are the surgical instruments, and this is a surgery being carried out by a doctor. This pictorial representation will help you to remember the case laws or examples. So breach of duty to take care, it means that the person who has an existing duty of care should act wisely, not commit any act which he is not supposed to. Case law is Ramesh Kumar Naik versus Union of India of 1994. Facts: one, Mr. Ramesh Kumar Naik was injured due to the collapse of a wall at a government post office building. The wall collapsed while Naik was near the building, leading to serious injuries. They claim Ramesh Kumar Naik filed a case against the Union of India, holding the government responsible for the unsafe condition of the post office building, which resulted in the collapse. The Supreme Court of India held that the Union of India, as the owner of the post office, was responsible for ensuring the safety of the building. Duty of care. The court emphasized that the government had a duty to maintain public buildings, especially those frequented by the public, such as post office, in a safe condition. Negligence. The unsafe condition of the post office was the unsafe condition of the post office wall amounted to negligence on the part of the government. Liability. The government was held liable for the injuries suffered by Ramesh Kumar Naik as a result of the post office wall collapse. Case law, one more case law. It is Municipal Corporation of Delhi versus Sobhagavanti. AIR 1966 SC 1750. Facts. This case involves the collapse of a clock tower in Chandni Chowk, Delhi, which resulted in the death of several people. The clock tower, built more than 80 years ago, collapsed due to its dilapidated condition. The Supreme Court of India held that the Municipal Corporation of Delhi, in short MCD, is liable for the collapse of the clock tower and the resulting deaths. The collapse of the tower was due to the negligence of the corporation, which had the responsibility to maintain it. The clock tower was under the ownership and control of the Municipal Corporation of Delhi, and it was their duty to ensure that it was maintained in a safe condition. Fourth is causation. The claimant must prove that the breach of duty caused the harm or damage. This is typically divided into two parts. Factual causation. The harm would not have occurred, but it occurred due to the defendant's actions. Legal causation. The harm must be a reasonably foreseeable result of the defendant's breach. Damage. The claimant must prove they suffered actual harm or damage as a result of the defendant's breach. This could include physical injury, property damage, or financial loss. So these five are the essential elements to constitute negligence. Coming to question number 2, explain the maxim res ipsa loquitur. Answer: res ipsa loquitur. It is a Latin legal maxim. It means the thing speaks for itself. खुद बयान कर रहे हैं. In tort law, it refers to a doctrine that allows a presumption of negligence to be made in certain cases where the nature of the accident or injury is such that it would not ordinarily occur without negligence on someone's part. Essential elements of res ipsa loquitur. Nature of the accident. The event must be one that typically does not occur in the absence of negligence. Example: if a surgical instrument is left inside a patient after surgery, this would generally indicate negligence. Control. The defendant must have been in control of the situation that caused the harm. This suggests that the defendant had the opportunity to prevent the harm from occurring. Exclusion of other causes. The plaintiff must show that the defendant's negligence was the cause for the injury. Application. There must be no evidence of the actual causation of the accident. This is wrongly typed something, application. Please ignore it. So the fourth essential is there must be no evidence of the actual cause of the accident. In cases where res ipsa loquitur applies, the burden of proof may shift to the defendant to demonstrate that they were not negligent. This doctrine is particularly useful in medical malpractice cases, product liability cases, and other scenarios where direct evidence of negligence is difficult to obtain. Case law 1, S. Vedanta Acharya versus Highway Department of South Arcot, 1987. Arcot is a place in Tamil Nadu. Facts. A bus plunged into the river after a culvert maintained by the Highways Department of South Arcot. The plaintiff's son died in the incident. Judgment. The Supreme Court held that the authorities of Highways Department of South Arcot had not made suitable provisions for strengthening the culvert before the rain in order to prevent such a calamity. Case law 2, Wakelin versus London and South Western Railway Corporation of 1886 is a landmark English case concerning the application of the doctrine of res ipsa loquitur in negligence cases. Facts. A man, the deceased, was killed by a train operated by the defendant railway company at a level crossing. The plaintiff, Wakelin, brought an action against the railway company alleging negligence on the part of the railway company in operating its trains. The railway company contended that there was no direct evidence of negligence and that the deceased might have been responsible for his own death by attempting to cross the tracks without proper care. Judgment. The court ruled in favor of the defendant, London and South Western Railway Company. The key points of the judgment were application of res ipsa loquitur. The court held that res ipsa loquitur could not be applied in this case. The accident itself, a person being killed by a train, did not automatically indicate negligence by the railway company. In this case, there were other possible explanations for the accident, such as the deceased attempting to cross the track at the wrong time. Second point of the judgment is requirement for direct evidence. The court emphasized that in order to succeed, the plaintiff had to provide direct evidence of negligence. Since there was no evidence that the railway company had failed to follow the necessary precautions, like using proper signals, ensuring the crossing was clear, the mere fact of the accident was insufficient to prove negligence. Burden of proof. The court held that the burden of proof remained on the plaintiff to show that the railway company had acted negligently and the plaintiff failed to do so. The doctrine of res ipsa loquitur could not be used to shift the burden of proof onto the railway company without stronger evidence indicating that the accident could only have occurred due to the negligence. Contributory negligence. The court also considered the possibility of contributory negligence by the deceased. It was possible that the deceased had not taken sufficient care when crossing the railway tracks, and without clear evidence of the railway company's fault, the court could not hold the defendants liable or guilty. Coming to question number 3, explain contributory negligence with leading case laws. Answer. Contributory negligence is a principle in tort law where the plaintiff's own negligence contribute to the harm they have suffered. This is the key word you must remember. In such cases, the plaintiff's compensation or damages may be reduced or the claim may be completely dismissed if the plaintiff is found partially responsible for the injury. Key elements of contributory negligence. Negligence by the plaintiff. The plaintiff must have failed to exercise reasonable care for their own safety. Contributory factor. The plaintiff's negligence must have contributed to the harm or injury they suffered. Effect on compensation. Depending on the legal system, the plaintiff's compensation can either be reduced or completely barred. Case law, Municipal Corporation of Greater Bombay versus Lakshman Iyer, a case of 2003. Facts. The plaintiffs were legal heirs of the man who fell into an open manhole on a public road in Mumbai and died. The Municipal Corporation of Greater Bombay, that is BMC, was responsible for maintaining the roads and the manholes. The open manhole had been left uncovered and unmarked, posing a serious danger to pedestrians. The plaintiff sued the BMC for negligence, claiming that the corporation failed to fulfill its duty of care to the public by not ensuring the manhole was properly covered. The BMC argued that the deceased person was walking negligently and did not exercise proper care while using the road and thus contributory negligence should apply. Judgment. The Supreme Court of India ruled in favor of the plaintiff, holding the Municipal Corporation of Greater Bombay liable for negligence. Before moving to the next slide, let me show you that this is a manhole cover normally found on the footpath or in public roads. So sometimes this is left open by mistake by the employees of the municipal corporation, and she is a young lady trying to cross the road, and here there is a manhole. So during darkness or when there is no supply or rainy days, there are quite chances that somebody like this lady may fall into this manhole if it is left opened. The key points of the judgment were negligence of the corporation. The court found that the BMC had clearly failed in its duty to maintain the manholes and public roads in a safe condition. Leaving a manhole open without any warning or protective measures constituted negligence on the part of the municipal authorities. Contributory negligence. The court rejected the defense of contributory negligence raised by the BMC. It ruled that the deceased could not be held responsible for his death because it was unreasonable to expect a pedestrian to anticipate the presence of an open and uncovered manhole on a public road. The court noted that pedestrians have a right to assume that public roads are safe for use and they are not required to be constantly vigilant for hidden dangers like uncovered manholes. Duty of care. The court emphasized that municipal authorities have a heightened duty of care to ensure that public infrastructure such as roads and manholes is safe for use by the public. Failure to fulfill this duty leads to liability in negligence. Case law second one is Butterfield versus Forrester, a case of 1809. Butterfield versus Forrester is a landmark English case that played a significant role in establishing the doctrine of contributory negligence in tort law. Facts. In this case, Forrester, the defendant, had placed a pole across part of a public road in front of his house while performing some repairs. This obstruction partially blocked the road. The plaintiff, Butterfield, was riding his horse at a very fast speed, and in the evening when he collided with the pole and he was injured. It was still light enough to see the pole, but Butterfield failed to notice the obstruction because he was not riding carefully. Butterfield filed a lawsuit against Forrester, claiming that Forrester's actions placing the pole in the road were negligent and that they caused his injuries. Here you can imagine somebody's house is there, he is repairing his house. So while repairing his house or doing some repairing work, he put a iron pole or electric pole kind of thing, and this man Butterfield, he was she's a lady of course, but you imagine that she is not a lady, so was crossing the road, so this thing happened. Judgment. The court ruled in favor of the defendant, Forrester, and Butterfield's claim was dismissed. The key points of the judgment were contributory negligence. The court found that Butterfield himself was negligent. Why? By not paying proper attention while riding his horse. The judge noted that if Butterfield had been riding with ordinary care, he would have noticed the obstruction and could have avoided the accident. Because of Butterfield's own negligence contributed to the accident, he could not recover damages from Forrester. Principle established. This case established the principle of contributory negligence in English common law. This is a very important question for CLAT, ISLET and DULB or LLM entrance examination. It laid down the rule that if a plaintiff's negligence contributes to their own injury, they are barred from recovering damages even if the defendant was also negligent. Not only for this entrance examination, these questions are also important for UGC NET in law and judiciary examinations. Reasonable care. The court emphasized that a person using a public road must exercise reasonable care. If they fail to do so and their lack of care contributes to an accident, they cannot hold others responsible for their consequences of their own actions. Case law 3, Davis versus Mann. It is a landmark case in English tort law that established the doctrine of last opportunity rule or last clear chance. The doctrine of last clear chance भी इसको कहते हैं, last opportunity rule भी कहते हैं, which is an exception to the rule of contributory negligence. Facts. The plaintiff Davis left his donkey tied by its legs on a public highway, which was negligent as it posed a danger to traffic. The defendant, here Mr. Mann, this is Mr. Mann suppose, was driving a wagon pulled by horses along the highway. See, he is driving a wagon. It is pulled by horses. You can see it. The horse is very little visible, but it is a wagon. It clearly shows it. Along the highway, Mann was driving at a faster pace than was reasonable under the circumstances and did not take sufficient care to avoid hitting the donkey. Despite seeing the donkey on the road, Mann failed to slow down or maneuver the wagon to avoid it. The donkey was struck and killed by the wagon. The poor donkey, whose two legs were tied by the owner, it died. Davis sued Mann for damages, claiming that Mann's negligence in driving too fast caused the death of his donkey. Mann argued that Davis was contributory negligent by leaving his donkeys fatted on the highway, which contributed to the accident. Fatted means two legs were tied with a rope, that is fatted. Last clear chance doctrine. The court introduced and applied the doctrine of last clear chance, which holds that even if the plaintiff was negligent, the defendant could still be held liable if the defendant had the last opportunity to avoid the accident and failed to do so. अगर वो दूर से ठीक से देखा होता तो ये एक्सीडेंट को अवॉइड की जा सकती थी और गधे का भी जान बच जाता. In this case, Mann had the last clear chance to avoid hitting the donkey, as he saw or should have seen the donkey on the road in time to take evasive action but failed to do so. Defendant's negligence as the proximate cause. Proximate cause means the closest cause or nearby cause. The court held that Mann's failure to take care while driving was the proximate cause of the donkey's death. Although Davis was negligent in leaving the donkey on the road, Mann could have avoided the accident if he had driven more carefully. Therefore, Mann was held liable for the damage. Fourth question, explain the doctrine of alternative danger in law of tort. Doctrine of alternative danger. The doctrine of alternative danger, it is also known as the doctrine of agony of the moment. It has another name, okay. Applies when a person is faced with an emergency or a sudden danger due to someone else's negligence. In such a situation, if the person takes an action that is not entirely rational or ideal under normal circumstances but is reasonable given the urgency, then may not be held liable for negligence. Essentials of doctrine of agony of the moment or doctrine of alternate danger are: there has to be an emergency situation, mind it. The person must have been placed in a situation of sudden danger by another's negligent act. Reasonable reaction. The person's reaction may not be perfect, but it should be a reasonable response in the given circumstances. See, jumping out of a moving car is not a perfect act, but the situation demanded him to do like that. Defendant's responsibility. If the defendant's negligent action created the emergency, then cannot argue that the plaintiff's reaction was wrong or contributed to the harm as long as the reaction was reasonable. Example, suppose a pedestrian jumps into the road to avoid being hit by a car driven negligently by the defendant, and in doing so they get hit by another vehicle. The doctrine of alternative danger would protect the pedestrian because their actions, although dangerous, were taken in an emergency caused by the defendant's negligence. Case law, Jones versus Boise, case of 1816. Facts. Jones, the plaintiff, was a passenger on a stagecoach operated by Boise, the defendant. As the stagecoach was traveling, it appeared to be out of control due to the driver's negligence in managing the horses. Jones, fearing that the coach was going to overturn and he would be injured, made a decision to jump off the moving coach to avoid what he perceived to be imminent danger. However, in doing so, Jones broke his leg. As it turned out, the coach did not actually overturn. No other passengers were injured. Jones sued Boise, claiming that the driver's negligence in creating the dangerous situation had caused him to jump and injure himself. Judgment. The court ruled in favor of Jones, the plaintiff, means who got injury. The key points of the judgment were application of the doctrine of alternate danger. The court held that Jones had acted reasonably under the circumstances, given that he believed he was in immediate danger due to the negligence of the defendant's driver. Although the coach did not overturn, the court recognized that Jones was placed in a situation where he had to make a quick decision to protect himself from the potential harm. Reasonableness of the plaintiff's actions. The court ruled that when someone is placed in a position of imminent danger due to another's negligence, their response should be judged based on what a reasonable person would do in the circumstances, not based on hindsight. Negligence of the defendant. The court found that the driver's negligent handling of the horses was the cause of the dangerous situation. Therefore, Boise, as the coach operator, was liable for the negligence of his driver and responsible for the injuries sustained by Jones. Fifth question, differentiate between doctrine of alternate danger and doctrine of contributory negligence. Basis, we will discuss it in a tabular form on the basis of comparison and what are they for both of them. Definition, doctrine of alternate danger. It is a principle that provides a defense to a person who acts to avoid imminent danger created by another's negligence, even if their actions are not ideal. For contributory negligence, it is a principle that holds a plaintiff partially responsible for their own injuries due to their negligent behavior. Application. Doctrine of alternate danger applies when a person is faced with an emergency or imminent danger due to someone else's negligence and acts reasonably in response. The contributory negligence applies when the plaintiff's own negligent actions contributed to the harm they suffered, potentially reducing or barring recovery. Focus. Doctrine of alternate danger focuses on the reasonableness of the actions taken in response to a perceived danger, regardless of the outcome. Contributory negligence focuses on the plaintiff's own behavior and how it contributed to the injury or harm suffered. Legal consequences. The plaintiff may still recover damages in the case of doctrine of alternate danger. The plaintiff may still recover damages if their actions were reasonable under the circumstances, even if those actions were not the best choice. In the case of contributory negligence, if it is proven, the plaintiff's compensation may be reduced proportionately or barred entirely depending on the jurisdiction. Question number 6. Can a child be held liable for contributory negligence? Support your answer with relevant case laws. No. This rule of contributory negligence is not applied in case of children. The courts take into account the inexperience, these are the key words, and lack of judgment power of children while deciding the cases involving them. Children are not mature enough as adults to judge the things correctly. Case law is Motias Costa versus Roque A. Jacinto, AIR 1976. In this case, Motias Costa, a 6-year-old child riding a bicycle, was crossing the road to reach his school. The defendant, Roque A. Jacinto, was driving a motor vehicle. As Costa was riding along the road, he was hit by Jacinto's motorcycle, resulting in injuries to Costa. The incident occurred on a road that had been recently repaired. The plaintiff alleged that the defendant was driving recklessly and at a high speed, which caused the collision. The plaintiff claimed that the Jacinto did not take proper care to avoid hitting him and that the defendant was negligent in his driving. Judgment. The court rejected the plea on the basis that it cannot be expected from a child that he would behave in a matured manner as an adult. The motorcyclist, as a reasonable person, could have anticipated that during the school hour, children would cross the road and he failed to drive the vehicle cautiously. Write a short note on composite negligence. Composite negligence refers to a situation where harm is caused to a person due to the negligence of two or more parties. Keywords. In such cases, the injured party can sue all the wrongdoers together or separately to claim compensation. Each of the wrongdoers is considered jointly and severally liable for the damage. This is another keyword. The injured person does not need to prove the degree of negligence by each wrongdoer. It is enough to show that their collective negligence resulted in harm. Explanation. Multiple parties at fault. There are two or more individuals whose negligence has contributed to the harm or injury. Explanation, you can say these are also the essentials. Liability. All negligent parties are held jointly and severally liable, meaning that the injured party can recover full compensation from any one of the wrongdoers, not apportionment for the injured. The injured party is not concerned with how the liability is distributed among the wrongdoers. Once the compensation is awarded, it is up to the negligent parties to claim contribution from each other. Distinction from contributory negligence. In contributory negligence, the injured party is partially at fault for the injury, whereas the composite negligence, the injured party is free from fault and the negligence lies entirely with the multiple wrongdoers. If this point 3, if you are getting confused, let me clear one thing, that A was injured by 3 people, B, C and D. So A can claim compensation from all these 3 together, severally, jointly, or A can claim compensation from any one of them. And the rest 2 can claim from B. B pays the claim to A. B can claim the contribution or proportionately the claimed amount from C and D at a later stage. This is what point number 3 is saying. Hope it is clear now. Example, 2 drivers due to their individual negligence cause an accident, injuring a pedestrian. The pedestrian can seek compensation from either driver or both. This doctrine ensures that the injured party gets full compensation without having to worry about apportioning the blame among the wrongdoers. Case law is Hira Devi versus Baba Kant Das, 1977. Hira Devi, the appellant, filed a case for compensation after an accident that caused the death of her husband. The accident occurred due to the collision of a bus and a tempo. Both vehicles were being driven negligently, leading to the death of her husband, who was a passenger in one of the vehicles. Judgment. The court held that in cases of composite negligence, all wrongdoers, in this case both the drivers of the bus and the tempo, are jointly and severally liable for the harm caused. This means that the injured party or the legal representatives, in this case Hira Devi, can recover the full amount of compensation from any one of the wrongdoers. Pedestrian is a person who is walking, especially in an area where vehicles are present, such as on a road or in a street. Apportioning means dividing or distributing something among different people or groups according to a specific rule or proportion. I think this is the last question. What is nuisance? What are the remedies available? Nuisance. It refers to an unlawful interference with a person's use or enjoyment of land or some right over it or in connection with it. It can be broadly categorized into 2 types, public nuisance and private nuisance. Private nuisance affects the rights of an individual or a limited number of individuals regarding their enjoyment of land. It involves an interference that is continuous or repetitive in nature. Key elements of private nuisance: unlawful interference. The interference must be unreasonable and causes substantial harm or inconvenience. Interference with use or enjoyment of land. The claimant must have an interest in the land that is being affected, such as ownership or tenancy. Examples: noise pollution, vibrations, smells, or anything that interferes with a person's enjoyment of their property. This is all about private nuisance. Public nuisance. Public nuisance affects the rights of the public or a section of the community rather than an individual. It is considered a crime as well as a tort. A person can bring a claim for public nuisance if they have suffered special damage beyond what the general public has suffered. The key elements of public nuisance are affecting the public at large. It must interfere with public rights such as obstructing a public road, polluting a public water source, or causing general harm to the community. To sue for public nuisance in a civil action, the individual must show they have suffered more damage than the general public if they want a special damage. Examples: blocking a highway, polluting a river than the public uses, or operating a business that affects public health, like opening a factory manufacturing hazardous chemicals. That is, operating a business that affects public health. Remedies for nuisance. Damages. Compensation for the harm caused by the nuisance. This is one remedy. Second is injunction. A court order to stop the nuisance from continuing. That is injunction. In short, we call it is stay order. Abatement. The claimant may take reasonable steps to stop the nuisance, that is trimming overhanging branches. Suppose there are overhanging branches of a tree, one could trim it. Example: if a factory emits excessive noise and smoke that interferes with a neighboring household's peaceful enjoyment of their property, it can be considered a private nuisance. If the same factory's pollution affects a large area and causes harm to the public, it may also be considered a public nuisance. Case law is Radheshyam versus Gur Prasad of 1978. A suit was filed. By mistake, suit was left out in it. Please bear with me. I am sorry for this. Okay. A suit was filed. Suit means a plaint was filed. A suit was filed to restrain defendants from installing a flour mill in the area where plaintiff was also residing, as it would cause nuisance to him. The court observed that sound of the flour mill machines would seriously interfere with the physical comfort of the plaintiff, and as such it amounted to nuisance, and the plaintiff was entitled to an injunction against the defendants. That is the end of this video, my friends. Hope you found it useful and exciting. Then please subscribe to my channel and hit the bell icon to get latest videos updated on subjects. Please like it and share it among your friends. Your comment on the video and what you want me to prepare is vital for upcoming videos. Do comment please. Good luck to you. Do well in exams. Do well in life. I wish you all the best. Thank you. Thank you for watching my video once again. Thank you.